I move to dispense with the calling of the roll.
Second.
It has been moved and seconded that the calling of the roll be dispensed with. The same is hereby dispensed with. Meron ba yung... May I request the COMSEC to please acknowledge the members and resource persons present.
Thank you, Your Honor. Good morning. The subcommittee on prosecutorial reforms and the subcommittee on investigation and enforcement reforms acknowledges the presence of the following members. We have Honorable Mahmoud Mending. We have Honorable Alfredo Garbin and Honorable Eugene Michael de Vera. We also have our member, Honorable Bernadette Herrera, author of the Anti-Hazing Law. For the guests, Your Honor, we have from the Department of Justice, Attorney Maricel Acayan. From the Public Attorney's Office, Attorney Nazario Bancoro Jr. From the DILG, we have Attorney Eileen Grace Uy Deticio. From the Philippine National Police, we have Police Chief Superintendent Fausto Manzanilla Jr. From the Supreme Court, Office of the Court Administrator, we have Deputy Court Administrator Raul Villanueva. From the Philippine National Police Academy, we have Police Chief Superintendent Randolph Delfin. From the Philippine Military Academy, we have Major Gerald Cabrera. From the AFP, we have Major Eduardo Esquivias. We've also invited guests from the NBI, from the National Prosecution Service, from the Philippine Judges Association, from the Department of Education, from the Commission on Higher Education, from the National Youth Commission, and from the UP Law Center.
Thank you for that, and also to our partners from the media. I hate to disappoint you, but you know, in my committee, in the Committee on Justice, we would like to focus more on the work rather than the endless investigation. And so we are way ahead of time insofar as the hazing incidents are concerned, because while you know, they're discussing this elsewhere, we have already crafted our version of the anti-hazing law that we hope will address the many ills and the ailments of the existing law towards making this the law more strict and will be difficult to violate. So anyway, but it would be a good opportunity for you also to hear many other initiatives that we have on criminal justice system reform, and because we have here, of course, the Deputy Court Administrator of the Supreme Court, who will give us a briefing on our way forward in terms of enhancing and reforming the investigation aspect of the criminal justice system towards a better model that will hasten resolution of cases, indictment of respondents or accused, and eventually, hopefully, that will speed up the administration of justice. So anyway, let me greet everyone a pleasant morning, of course, to the distinguished members of the Committee on Justice and the Subcommittee on Prosecutorial Reforms and Subcommittee on Investigation and Enforcement Reforms. Today, we will conduct two meetings to deliberate two priority measures identified by the House leadership. I am pitching in for my vice chairman so that we will not derail the consideration of this measure, so that we can immediately bring this to the level of the mother committee, of which I am the chair. So you will again see me when we pass upon these measures at the mother committee level. But for now, the first is the meeting of the Subcommittee on Prosecutorial Reforms headed by Vice Chairman Doy Leachon, also from Mindoro, who is unable to be with us today due to a conflict of schedule, but will nevertheless, because tomorrow I will have conflict of schedule in my other assignment as Vice Chair of JCPC. We will have a joint Congressional Power Commission meeting tomorrow, so I asked him to chair the committee hearing tomorrow that will also consider this measure. This measure is House Bill number 3467, authored by Representative B.H. Herrera D., which is the revised Anti-Hazing Law. This measure was already identified by the House leadership as a priority bill way before the most recent death of another hazing victim was reported in the news. Kanya nga na medyo nagulat ako dahil dati naman hindi naman controversial to, tapos nung hihiringin na namin naging biglang controversial, ano. Meron yata akong mutya ng kontrobersya. Hindi naman, hinahabol lang, pero hindi naman ako yung controversial, yung mga hinihiring namin. Anyway, this is extremely unfortunate event, is in no way also fortuitous, since it is a testament to the timeliness of this measure and the pressing need to strengthen our laws to prevent such needless loss of life, full of promise and potential. The technical working group already met and refined the provisions of the bill, and we will later recognize the author and co-chair of the TWG. Of course, this is Representative BH, and I'd like to thank you for, speeding this up and even overtaking what had happened, or the most recent incident of the Castillo hazing death, no? We also have representatives from various concerned stakeholders, namely PNPA, the PMA, the Department of Education, and the Commission on Higher Education to give their comments on this measure. The other measure that we will tackle today is one under Subcommittee on Investigation and Enforcement Reforms headed by Vice Chair Strike Revilla, who cannot also be with us today for health reasons. In this meeting, we will deliberate on the substitute bill to House Bill numbers 8 and 775 on the Criminal Investigation Act. The technical working group composed of COMSEC, the DOJ, PAO, and PNP met and discussed the consolidation of the bills, and the COMSEC will present to us the technical working group report on the output of the meeting. This bill is also very timely and forms a crucial part in our efforts to reform the criminal justice system. This proposed measure seeks to overhaul our criminal investigation system and pattern it with the criminal investigation system in perhaps Korea and or America or even Japan, no? We have already here as our resource person, as mentioned earlier, Deputy Court Administrator Raul Villanueva, who will present to us the criminal investigation system as practiced in South Korea and in America, to enlighten us on the differences among the systems in investigating crimes and to help us close the gap in the investigative practices and procedures in our jurisdiction in order to raise the conviction rate and consequently hasten the administration of justice in our country. So at this juncture, may I now recognize Representative BH to deliver her speech on the substitute measure on the anti-hazing bill. You have the floor, BH.
Maraming salamat, Mr. Chairman. And again, maraming pong salamat for speeding up this process. Although you would like to highlight that we were already on this process of taking this up even before the sad incident happened. So this highlights that the Congress, the House of Representatives, is really doing its job. And those the importance of amending the existing law to avoid what happened just last week. So, Mr. Chair, to the members of the Committee on Justice, to my colleagues, and to the guests, resource persons, good morning. As author of House Bill 3467, or the revised Anti-Hazing Law, I am pleased to report to the Subcommittee on Prosecutorial Reforms the progress of the Anti-Hazing Bill as discussed in the Technical Working Group meeting last September 7, 2017. So to begin with, we have expressly prohibited, so this is the number one difference from RA 8049, we have expressly prohibited hazing and regulated the initiation rights of fraternities, sororities, and other organizations as can be gleaned in the title. So the title would read now as follows: an act prohibiting hazing and regulating other forms of initiation rights of fraternities, sororities, and other organizations, and providing penalties for violation thereof, repealing for the purpose Republic Act number 8049. I hope everyone has the matrix so that we can follow and we could suggest amendments later on, if any. So the main difference, Mr. Chair, is that in the Republic Act 8049, we were regulating hazing. As opposed to this, we are completely prohibiting any forms of hazing. Second, we have expanded the definition of hazing to include not only physical but also psychological injuries caused to the neophyte. If you will please look at Section 2 in the definition of terms, paragraph 1 of the draft bill, it defines there, and we added psychological injuries and not just physical. We also defined initiation or initiation rights. This was also absent in the previous Republic Act to distinguish the same from the term hazing. So that's letter B in the said matrix. We have already defined what initiation rights mean. And then letter C, for the term organization, the testing, training, procedure, and practices to determine the physical, mental, and psychological fitness of prospective regular members of AFP and PNP, which are not considered hazing, is extended to customary athletic events. So, dinagdag po natin yung customary athletic events. So, let me know lang if I'm going fast, Mr. Chair. Section 3 emphasizes the prohibition against all forms of hazing at whatever stage. The draft bill necessitates requirements that must be complied with before any initiation rights or practices may be held, both for school and community-based fraternities, sororities, and organizations. This is another highlight of this bill. We included already community-based fraternities, sororities, and organizations, and not just school-based. Kasi dati, walang community-based. So ngayon, sinama natin yung community-based fraternities, sororities, and organizations. We also took note of the suggestion to include the submission of a medical certificate by those who will be subjected to initiation rights. So this is combination of Section 4 and 10. There will also be monitoring of initiation rights, both for school and community-based fraternities, sororities, and organizations, to see to it that no hazing is conducted. Fraternities, sororities, and other organizations are now required to register with the school or the local government unit, as the case may be. Since we included the community-based fraternities, sororities, and organizations, they would have to register now with the local government unit as one of the accredited organizations or NGOs. Likewise included is the assignment of a faculty advisor who will be responsible for the monitoring of activities of fraternity, sorority, or organization. and mandates the educational institutions to disseminate information at the start of every semester regarding the consequences of conducting of and participating in hazing. That is Section 7 and 8. Another highlight of this bill is the inclusion of impermissible defenses so that the consent of the victim shall not exempt the perpetrator from liability. So, dinagdag po natin yun, Mr. Chair, yung impermissible defenses.
Anong section? 12.
Section 12. Para hindi excuse na porket may waiver yung bata, exempted na. Also, under Section 14, a prosecution under the measure will not bar a prosecution for other offenses. So, pag kunwari inutusan na, kunwari nakawin mo to or inutusan ng master yung fight na may gawin, it won't be excused from other offenses. Under Section 17, we retained the penalties under RA 8048 for physical injuries inflicted on the victim and made psychological injury likewise punishable. But on top of imprisonment, we also added fines as additional penalties to RA 8048. So we now added psychological injury with penalties and at the same time added fines. Of course, it's graduated depending on the gravity of the offense. So having said that, Mr. Chair, I thank the subcommittee for their assistance in the refinement of this draft bill. However, it is still desirable, if not necessary, to listen to our invited resource persons for their recommendations and insights to further improve this measure. But so far, these are the highlights of the major differences and a leap from RA 8048, Mr. Chair.
Thank you, Kong BH. At this
Sorry,
juncture,
8049.
at this juncture, I recognize Congressman Garbin for some comments.
Thank you, Mr. Chair. This representation, and including the two representatives of a Bicol party list, had also filed an amendment to Republic Act 8049 and our proposed bill, House Bill 3137 or 3731 was referred to the revision on laws. However, upon perusal of the substitute bill, or proposed amendments to House Bill or to Republic Act 8049 is already subsumed to the substitute. But let me just highlight our proposed amendment in contribution to the substitute bill. In the landmark decision of the Supreme Court, wherein 5 members of Aquila Legis Juris Fraternity was found guilty of reckless imprudence resulting to the death of Lenny Villa 20 years ago during the organization's initiation rites. The Supreme Court recommended that Congress amend Anti-Hazing Law to include the fact of intoxication in the presence of non-resident or alumni fraternity members during hazing as an aggravating circumstance that would increase the applicable penalties. Now, our proposed amendment is the answer to that call made by the decision of the Supreme Court in the case of Lenny Villa. That amendment seeks to include the said circumstance as an aggravating circumstance to consider the application of penalties of violators under Republic Act 8049. It is also our determination that the state, as a declaration of policy, should condemn all acts of fraternity-related violence, most especially those happening in academic environment. This includes initiation rites that subjects the neophytes to intense physical and psychological torture. And we also called for stricter law that penalize hazing persists to stop the danger it poses to the lives of the youth. A recent example is the case of Horacio Castillo. 2 years ago or 3 years ago, the case of Cesar Servando, a student of the La Salle College of St. Benil, who died June of 2014 because of hazing. And this is just to name a few, Mr. Chair. So when I peruse the substitute bill to House Bill number 3467, it was already included in Section 17, particularly letter G, when the hazing involves the consumption of alcoholic product or drug or illegal substance. And on the fifth to the last paragraph, it was also mentioned here that the officers, former officers or alumni of the fraternity, sorority, or organization who actually planned the hazing, although not present when the acts constituting hazing were committed, shall be liable as principals. And these are all considered as aggravating circumstances, meaning they will all be meted the maximum penalty as herein provided in the proposed amendment to Republic Act 8049. So, may I request, Mr. Chair, and to the Councilor Bernadette Herrera, that we be included as one of the authors of the proposed amendment to Republic Act 8049.
Accepted, Mr. Chair, and I'm happy that they also have this bill. It highlights the fact that this is really needed. Pasensya na po kayo kay Congressman Garbin. Magkasama po kaming konsehal noon.
Salamat.
And at this juncture, I'd like to, of course, express my supreme gratitude to the TWG headed by BH for being comprehensive. I mean, you know, we still have some other bills pending, and in fact, I was told that this will be referred soonest by the Rules Committee to the Committee on Justice. Actually, I really don't know why this is under Committee on Justice. This should have been revision of laws, but then probably the House leadership knows how fast we consider all of these measures, because what I did was really to organize and empower my 5 subcommittees headed by my 5 vice chairs. And so we are like a mill here that really mills measures without delay. And so this is why we are way ahead of everybody else in terms of coming up and producing the necessary measures so that, you know, we will not be stymied by the many legislative inquiries that are being conducted that really occupies so much of the time of Congress and of the people, because, and that is why I was begging the indulgence of our friends from the media that, you know, the fireworks or fanfare that probably they're looking at or expecting for this hearing is not there or will not be there, no? Because we already have the bill to be approved, and this is primarily what Congress is all about. This is to legislate, and we'd like to stay focused on our primary task of legislating. And so, again, thank you, BH, and the rest of the members of the technical working group. Kong Mac.
Thank you, Mr. Chair. I have a clarification as to the registration of fraternities, sororities, and organizations. This bill makes it mandatory, right?
Yes.
Would there be a penalty if there is a fraternity or organization that did not register?
Yes, there will be administrative sanctions. It's in section page, hold on, page 3.
Of the bill.
Sorry, page 3 of the bill.
Line 46.
Line 46. Sa bill, sorry, sa bill.
Thank you. I was just wondering if, since we made it mandatory, if
Yeah.
they did not comply, what would be the penalty? So it is administrative.
Yes, it is.
Thank you. So I guess, Mr. Chair, the author has explained this and it has gone through the TWG.
Well, perhaps we can hear from our resource
Resource
persons.
persons.
Attorney Akayan from DOJ, any comments and or suggestions on how we can better improve this bill that we are now considering?
Thank you, Mr. Chair. The department has already submitted its position paper, and upon perusal of the substitute bill, we are very happy that our suggestions has already been incorporated therein, specifically the definition of initiation rights, which are now being regulated, the definition of what would include psychological injury as a punishable act. And of course, we also stated in our position paper that the committee should consider the suggestion of the Supreme Court in Dungo versus People, specifically the consideration of psychological harm done to the victim as an possible amendment to the present law.
How's that again? Can you please repeat?
Yes, Your Honor. We noticed that under the proposed bill, the substitute bill, our suggestions that we stated in our position paper has been incorporated, specifically the definition of initiation rights, as well as the inclusion of psychological harm, which was also stated by the Supreme Court in its decision in Dungo versus People. It also included what constitutes psychological injury as a punishable act. That would be, Your Honor.
Thank you for that. We now request from the Public Attorney's Office, Attorney Rosario Bancoro Jr.
Good morning, Your Honor. The Public Attorney's Office fully support the enactment of the revised anti-hazing law. However, we noticed that in the aggravating circumstance, as we discussed in the TWG meeting, that the use of the motor vehicle is already deleted during the meeting, and also the use of a drug, it is qualified by the word illegal drug, and other substance and other controlled substances are not changed, Your Honor. That is.
We're talking about Section F.
May I know the rationale for on the matter of the illegal drugs and controlled substances? We will the sponsor has agreed to consider this and will incorporate it as part of the bill. But may the chair ask you your rationale for your desire to delete the use of a motor vehicle?
Actually, Mr. Chair, during the last TWG meeting, the deletion of the use of motor vehicle was deleted because in going to the place where the supposed hazing is to be conducted, we will use or the participant will use a motor vehicle. That per se will constitute as aggravating circumstance. So in going to the place, what other means they can use is just by walking, Your Honor.
So you're saying it's already an aggravating circumstance under existing law?
Yes, Your Honor. Once you ride a jeepney or a tricycle in going to the venue, that is considered already an aggravating circumstance because it is not clear in the paragraph F, Your Honor.
The provision here says that the maximum penalty herein provided shall be imposed in any of the following instances. So it qualifies. It qualifies the crime when you use a motor vehicle, then you impose the maximum penalty rather than just an aggravating circumstance, which may be countered by a mitigating circumstance, di ba? So yun yung epekto nun, if it is just an aggravating circumstance. Whereas if you qualify it, then you are required to impose the maximum penalty already. No aggravating or mitigating circumstance will outdo each other.
Your Honor, as I understand, during the last DWG meeting, there is no mitigating circumstance that will be appreciated in this anti-hazing.
No, but what I'm saying is on the general principles.
Yes, sir.
Pag aggravating lang yan, merong mitigating that
Yes, Your
will
Honor.
counter it, di ba? So, ngayon, pero that is an appreciation of evidence. So,
Okay.
that will really be dependent on the courts. So,
Your
gaya
Honor,
nung surrender, kung sumurrender, mitigating yun.
Okay po.
So, hindi mo pwedeng i-exclude yun as a mitigating circumstance or not allow it to be a mitigating because that is a mitigating circumstance.
I submit to
ang-
the discretion of the Honorable Chair.
So, but would you now consider including it as a qualifying circumstance for the imposition of the maximum penalty rather than just consider it as aggravating?
Your Honor, I think the attendant of the motor vehicle qualifies the imposition of the heavier penalty.
Yes, that's correct. That is the intention.
Yes, Your Honor.
So you are amenable to it now?
Oh, yes, okay.
Okay. Thank you.
So okay na po.
Okay na po, ma'am.
Okay, thank you. We will have this rephrase, yung sa illegal and controlled substances. We'll fix that. Letter G, we'll fix that. So letter F, or for okay, then it's retained. All right. Thank you for that, Attorney.
Any more comments from your end?
No more, Your Honor.
So we now recognize Attorney Eileen Grace Uy de Tisio for the DILG.
Good morning, Honorable Chairman and honorable members. We're happy that most of the manifestations made by Undersecretary Castriciones during the last committee hearing was taken into account, especially the medical report. However, we would like to reiterate again Section 15 or suits by the victim, since the person who could initiate the filing of the action is only the person against whom the hazing is directed. We have mentioned previously that as also members of sororities and fraternities, in any school organization, a quitter or anybody who interjects opposition to a fraternity or sorority carries a certain stigma of a squealer syndrome. And in this regard, may we request to consider our suggestion that the action or the suit filed may be brought by any person, not just by the victim himself, even on occasions of injuries.
Mr. Chair, I think the provision section 15 states that the person against whom hazing is directed may commence a civil action for injury or damages at any stage of the proceeding.
Yes, Your
So
Honor.
it is referred to a civil action which may only be filed by the one who actually suffered damages.
Yes,
Because
Your
it is
Honor.
civil. Kung criminal, anybody
Yes,
can
Your
file
Honor.
that.
May we consider that, at least for the statement, that any person for criminal action may be brought against the erring participants of the hazing procedures.
We'll take note of that, Attorney. Thank you very much
Thank
for
you,
bringing
Your
it up.
Pero yung sabi mong ano yun, yung quitter syndrome, how does it affect the bill?
Your Honor, usually, I belong to a sorority, and Undersecretary Castriciones
And
is
so am
previously
I.
a PNP. I think most of us here are members of fraternities and sororities and underwent the same initiation rites as mandated by our organizations. And probably the carelessness of the youth are not being brought about, are now being guarded against by the wisdom of our maturity, especially once you start having kids. I have kids of my own, and despite the fact that I am also a member of a sorority, I wouldn't want them to join any sorority. I think the fear of being inflicted with the pain would definitely, I think any mother would be pained for that, at least the apprehended pain brought about by the initiation rites.
So no fear now if we pass this.
Yes, Your Honor. I'm actually very happy as a mother that, this is actually being proposed. And on that note, most often, I came from the University of the Philippines, and most often than not, in the middle of any initiation or even during the neophyte stage, a student who quits the process are immediately ostracized in the community. They can no longer enter any other organizations because of the squealer syndrome or the quitter syndrome. And in this regard, if a case is being brought against a certain organization, most often, the stigma it carries and the isolation it will be brought to the student or the quitter participant will last all throughout his academic life.
So okay, yeah. So again, we will be able to address that because with this bill, then there will be no more quitters because there will be nothing to fear about in going through an initiation without any physical or psychological rights. Di ba?
Yes, Your Honor.
So ano na lang, magpirmahan na lang tayo. So thank you. Any more comments?
That would be at least the last proposal that we have, since we have already submitted
So thank
our
you,
position papers.
Eileen. And then we now call on Chief Superintendent Manzanilla of the PNP for his comment.
Yes, sir, for the PNP concern. By the way, good morning, everyone, Mr. Chairman. For the last meeting during technical working group, we have already aired our concern, and we believe that it's already incorporated in today's agenda. So that's all for the meantime, Your Honor.
Okay, yeah. So any more comments from Ched, Director Liveta?
Good morning, Honorable Chair and member of the committee. The Commission
Eileen.
condemns the recent death due to hazing in UST, and the Commission supports the proposed bill, and this also complement the existing issuance of the commissions insofar as the student activity for the student welfare. And so promotions in the Commission's policy for student activity provide such kind of mechanism for the higher education institutions to establish activity to strengthen the welfare of the students. And with that, we also would like to propose in the proposed regulations of initiations right, because in the most of the activity done by the fraternity, those involved in accident usually goes underground, and usually it did not communicated to the school authority, and so the accident happened because it was intentionally violated all the provisions. Even we have that kind of prohibitions or applications of activity, even that is scheduled. If they want to go that underground, so they will still do that. Now, maybe we could suggest, because since this is an activity or organizations within the higher education institutions, maybe we can limit the place of the initiation rites within the campus, outside the campus. And
Well, in this bill, it is actually included as one of the aggravating circumstances that if they hold it outside of school grounds, kasama siya.
yes, Madam. But if we could provide in the requirement that activity of such rights could be done in the institutions, there are from that. The institutions are involved from the very beginning. The facility could be provided by the
Mr. Chair, I leave it up to you, but in this bill, being it's one of the aggravating circumstances, so it's implied that you cannot hold those activities outside. But then again, I leave it up to the committee if you want to expressly state it.
Yeah. Well, the problem with that is, as you said, definitely a fraternity or sorority would go underground if they would conduct this outside of the school. So I don't know how you can handle that, how you can monitor that, no? So prohibiting it to be done elsewhere is something that is beyond the control of the school. And so the best way by which you can address that is impose a heavier penalty, which is already what is contained in the bill, no? So this is letter D of section 17. So unless you have other suggestions on how we can simply limit the rights in school or in the school premises, then how do you want to, what is your proposal on this?
maybe if we cannot do a mandatory within the institutions, maybe preferably if the plan of the organizations plan it within the institutions, if they could have that first choice or an option.
No, it is implied you have to do it in school, no? But then, since you cannot control the officers from holding it outside because for whatever reason they would want to hold it outside, then hold them accountable. Ganun ang,
Yes, sir.
di ba? So, and holding it accountable means that you impose a heavier penalty on
Doing that outside the campus.
if they do it outside the campus.
Mr. Chair, in addition to that, since this is a regulatory measure, the proposed bill requires under Section 4, Paragraph B, the written application shall indicate the place and date of the initiation rights. Therefore, the school would know where it will take place and what time and what day.
Yeah, including the dates. But we thought of doing the rights within the campus, since the organization is as part of their brotherhood activity during their school days.
Mr. Chair, and also, meron pa tayong Section 5, yung monitoring of initiation rights. It says here, the head of the school or an authorized representative must assign at least 2 representatives of the school. So, present sila, alam nila. So
And-
it has to be in the school premises. So if and when, like sabi nga ni Chair, hindi mo naman, nandito na lahat to eh, but if they still violate it, that's why it's an aggravating circumstance that if you hold it outside school, then the maximum penalty will be imposed upon them.
And also maybe the institutions must provide such facility for such initiations. Otherwise, if the school says that they do not have such facility for the initiation rites, so that's the problem with the fraternity. So the institutions must complement in their assistance in providing such facility for.
You know, that is a sound suggestion, no? Kasi you know, that may open the floodgates for conduct of rights outside if the school will not provide for that yes, a venue. Baka DCA Raul, baka you might wish to participate, okay lang, ha? Baka meron kang suggestion dyan.
If I may, Your Honor. Good morning po. Your Honor, may I just, although I am not officially a resource person in this particular bill under consideration, but I did attend.
But you are an expert witness.
I did attend the previous committee hearing on this one, and also gave my comments. So, and in doing so, I did gave some comments as not in my official capacity, Your Honor, but as an experienced member of a fraternity as well. May I just state, Your Honor, that I guess because of what happened recently involving a student from UST, there are calls for, among others, no, the dean, no, being held accountable for such incident. I think the reason for that is because, you know, to prevent hazing, much can be done if the school authorities are actually, no, very strict in implementing the law, no, on anti-hazing. And to my mind, Your Honors, perhaps it can be considered to really, no, to really make them accountable and responsible, and to prevent these kinds of death, no, and unnecessary deaths. Perhaps the school authorities and even the institution heads, because there are some institutions where there are fraternities, Your Honors, and this is not included in the bill, Your Honor, they should be held accountable whether or not they knew, no, that the hazing happened, no, when there is death or serious physical injuries that result, no, from the hazing activity. Because at this point in time, the law requires that there should be knowledge, no, on the part of the school authorities before they can be held accountable. To my mind, Your Honors, it can be legislated that whether or not there is knowledge on the part of the dean or the heads of the institutions, so long as there is death, Your Honor, or serious physical injuries that results, then they should be held accountable already. To my mind, if this will be included, it may enjoin, no, these school heads to really, no, to really make sure that these activities are really regulated, because otherwise they will not do anything and they will keep on pleading innocence, no, to those activities, and they will always go scot-free, Your Honors.
Parang naalala ko yun sa torts and damages, di ba? Merong ganyan, eh, no? Kaya lang, it's very...
No fault provisions.
No fault provision.
Yes, Your Honor. Whether or not there is fault on their part, they can be held liable, Your Honor, because of the death. No?
That suggestion is noteworthy. Perhaps the TWG may wish to consider this. And, you know, since we are tackling this and we are bent on approving this today, then we will consider that as also incorporated and approve this subject to style. Please, sige, please continue.
Sorry, meron pa. Maybe we could also suggest...
yung previous issue natin, yung sa school, okay na rin sa yon na what do you call this, maximum penalty, di ba?
Hindi, parang gusto niya kasi specifically isulat na that initiation rights should be made within the premises of the school. Therefore, the school should provide the necessary area or space to do that within the school premises. That's the suggestion of Director Liveta,
Okay.
Mr. Chair.
And also, okay na po kami dun, Kong. At,
So, walang exception yon. So, when you hold it outside, kasi may mga provisions tayo, how do you now reconcile that? Kasi kung merong notice of holding it elsewhere, then that presupposes that initiation rights are allowed outside. Di ba? So, kailangan i-fine-tune yung kung gano'n ang direction, i-fine-tune yun di gawin natin exception unless the school has no space to to provide for this the conduct of these rights.
Pero magiging excuse yun to hold it outside. Ma-affect
So, wag na.
If you put that exemption, then the aggravating circumstance might be affected in that sense, Mr. Chair. That's my worry if we put those exceptions because
So-
it is already implied naman in the bill that if you hold it outside the school, then it's an aggravating circumstances, aggravating circumstance if something happens. Kaya it's implied that
Ako, yung personal experience ko dito is that you know, what is important is that the school authorities must know that there are these things happening. In fact, to my recollection, during my time, and I think until today, parang hindi yata recognize sa eskwelahan yung fraternity ko eh. Until now,
at least yung sir.
And that is wrong. You know, the reason why they conduct it elsewhere and they hide it from school authorities is because they don't recognize the fraternities or sororities from the very start. So that if they are recognized, perhaps you know, they will be more responsible in the conduct of the affairs of the fraternity. And this is the reason why maganda yung suggestion that recognition of these organizations is mandatory. And then, yun na nga, yung holding it elsewhere may also be allowed subject to certain conditions. So it's not also good na sabihin natin sa school premises lang kayo because that might not be operable also. Baka hindi rin mangyayari.
Yeah, and Mr. Chair.
So we might as well cover all conceivable aspects of the rights through that information that will be given to the school authorities for the conduct or for the performance of their duties during these rights. Baka siguro mas magandang ganun na lang. Huwag na nating ilimit sa school lang.
baka siguro i-qualify natin only in highly exceptional cases and prior approval of the institution.
Didefine pa natin yung highly exceptional case na yun.
And
Para
Mr.
medyo merong limit ng kaunti siguro, Kong, so that baka in all activities they will venture of doing
Mr.
that.
Chair.
Siguro this can be covered by the implementing rules. Kung gano'n na lang, then we ought to cover this in the implementing rules rather than the law. Yun.
Yes, and Mr. Chair, nandito naman, meron tayong section na may school authorities na kasama, may faculty advisor pa, and then nandun naman lahat ng details. So if the school really wants to prohibit it from doing outside because they have the premises, pwede nilang sabihin, we're only allowing you within the school premises.
Pero dapat i-qualify natin yung participation ng school authorities. Dapat hindi sila miyembro ng fraternity na parang yung aegis juris, di ba? Si Dean mismong founder yata nito. And so if they send a school representative who are also members of the same fraternity, then it defeats the purpose. So dapat hindi siya kasali or hindi siya miyembro of the same fraternity or organization that will go through the process, di ba? Qualify lang natin yan.
I understand last night with Senate hearing, parang Dean Divina file a leave of absent para parang separated siya dun sa ano. Baka that could be part of the requirement. Kasi kung you are part of the fraternity during your college days and later you become officers of the institutions, so you still be part of those fraternities.
Sige, so anyway, moving on, yun na nga yung kaninang kinonsider because siguro that will now cover the responsibility and liability of school authorities, no? So, in that sense, covered na rin natin yun. Sige, please continue.
Siguro kung last concern na lang, maybe we could also include as part of the provisions, the promotions of programs and projects. So in those programs and projects, maybe we could have a collaborative meeting among all heads of the fraternities, so that within the institutions there are harmonious relationship with those heads of fraternities. And the regular gathering of those fraternities, maybe within the institutions, they could have a sports festival or cultural events or even academic, so that collaborative within the fraternities in the institutions could be established. Although kanina parang minabanggit yata ang waiver of the parents, so maybe part dun sa participation of the students to become member of the fraternity is a requirement for the informations of the parents, so that the parents from the very beginning been informed or have a consent.
Director, ganong karami, how extensive is yung fraternities in high school or even in elementary? Marami ba yan? Kasi sa college, marami, tsaka law and other professions, no? Pero sa high school, although alam ko meron yung mga acro, di ba, yung mga ganun. Meron din, pero hindi ko lang alam kung taugama, yung ganun. Hindi ko lang alam kung ganong ka-extensive yan in high school or elementary.
I just do not know kung DepEd provides such recognition in the elementary and high school. But during my high school days, parang the same din eh. The institutions did not recognize existence of those fraternities. But fraternity happened in high school through the extensions of those college. The college fraternity extended their associations in high schools. That's why meron din. But I just do not know if...
Yes, Mr. Chair. That's why we included in this bill the community-based organizations. Kasi normally sa high school, talaga namang pinagbabawal yung fraternities and sororities eh. So nagiging sa community-based sila pumapasok. Hindi naman sa school kasi hindi naman ina-accredit ng schools yan eh. Yung fraternities and sororities in high schools, they don't exist as far as schools are concerned. Kaya pumapasok siya sa community-based. Kaya sinama na rin natin yung community-based because of these happenings, Mr. Chair.
So, so covered din sila. Yun yung worry ko eh, kasi kung wala tayong ganon sa high school and there are, in fact, organizations in that level, then hindi comprehensive yung batas natin. So, it's a good thing that these are also covered through yung community-based organizations.
Mr. Chair. Mr. Chair.
Congressman Garvin.
Yeah, just an observation to Section 17 under page 10 of the matrix. There seems to be a great disparity between the degree of penalty that will be imposed upon the owner of the place where hazing is conducted, which he or she will be considered liable as principal, and to those school authorities, next paragraph, including faculty members as well as barangay, municipal or city officials, which only be held administratively liable even though they consented, if it is shown that they have consented or allowed the conduct of hazing. They must also be considered as principal. Because under the said paragraph, Mr. Chair, these school authorities or barangay officials or city officials will only be meted with the administrative liability as compared to the owner of the place who has actual knowledge and allowed the hazing in the said place. So I think consent and actual knowledge are the same.
You want them to be liable as principals?
Yes, yes.
The officers, former officers, hindi kasi naka-specify that they'll be liable as principals when they have actual knowledge.
Administrative lang ang liability.
So, we'll consider that. Pwede naman.
Any comment from anyone
Yes.
on this?
Si Justice yan.
Justice, please.
Your Honor, may I just, not a direct comment, but may I just add a little more regarding sometimes the difficulty in implementing this law? Because there are some terms that can really be interpreted one way or the other. For example, school authorities, Your Honor. School authorities may pertain to the dean, to the vice dean, or even to the president of the university. To my mind, and there are fraternities or sororities that are either based in a particular college or considered university-wide. No? So perhaps it can be considered, no, for purposes of ensuring that the law will really identify who will be held responsible insofar as a particular institution or a school is concerned, that this be identified. Who are these school authorities that are being referred to? Because otherwise, Your Honors, even up to, since the time that RA 8049 was enacted into law, up to this point in time, no school authority actually or any head of or administrators of institutions have actually been charged, Your Honor, simply because they do not know how to more or less identify who these school authorities being referred to. It's a small matter, Your Honors, but I think most victims actually, the first thing that they look at is the responsibility of the school authorities, because all of these fraternities and sororities actually, and even in some institutions, they operate in a particular surrounding, Your Honors. There is no such fraternity or sorority that operates without a base, Your Honor. There's always a base, no? And to my mind, this base should be clearly identified. Otherwise, it will be difficult really to implement or to hold all of these authorities accountable for. And so you end up, trying to prosecute only those who are involved directly. And since many have this code of silence or omerta, Your Honors, then definitely it would be difficult, to do so unless somebody comes out as a state witness, from the inside, proving first that there is hazing, and second, identifying who were involved in that. Otherwise, Your Honors, it's really going to be difficult to implement it. Perhaps that might be something that the committee can consider, Your Honors, because this is really one source of difficulty in implementing the law.
Thank you for that, Justice. Of course, the Chair would like to invite your attention to Section 18, Interagency Committee Against Hazing, where the CHED, DepEd, DOJ, PNP, AFP, DILG, DSWD, and National Youth Commission, and the organization representing the educational institution, colleges, etc., shall create an interagency to craft or promulgate guidelines and implementing rules and regulations. So I think this can very well be covered by this interagency committee against hazing. If I may just throw the question to the author, you may wish to also create an oversight committee so that at any step of the way Congress can step in to look into how this is being implemented, because we have had experiences like, for example, the anong pangalan nito, yung yung Bucor Modernization Act, no, took very long for DOJ to issue the implementing rules and regulations, and this has derailed the implementation of the Bucor Modernization Law.
In fact, Mr. Chair, most of our administrative as well as legislative recommendations regarding our hearing that we have conducted with regard to the proliferation of syndicates and drugs in the Bucor were not yet implemented by the Department of Justice right now.
Okay, so
As an observation.
that is the reason why. In fact, we have a standing order to DOJ to give us updates every now and then. I think every 6 months. Is that it? Anyway, just on a side issue, let us write DOJ to comply with the directive of the committee for them to submit to us updates on how they are performing the or how they are executing the recommendations of the committee. So perhaps Oversight Committee also may be a welcome inclusion in this bill.
Yes, Mr. Chair. Thank you. We'll take note of that.
So, yan, okay din yun, ano? So, IRR. Pero, as it is, so, i-fine-tune na lang natin. At the very least, immediately, school authorities will be held administratively liable. Meaning, dapat tanggalin yan or i-freeze yan or whatever so that they cannot anymore function as such. And then you know, this sends a strong signal to the stakeholders that action has immediately been taken
Yes.
on a particular, especially if it results to death.
Mr. Chair, yes, that's why I'm amenable to the suggestion of Justice Villanueva that if it resorts to death or serious physical injuries, that we should really punish immediately the school authorities, because we know that they know what's happening, but they're just turning a blind eye. They know that it exists, and yet they're still not yet very much into it and monitoring things. But maybe with this recent incident and with this law being passed, then they will take it seriously. And thank you for that, Justice. And then we'll define in the IRR the school authorities, because I understand, yeah, it could be a dean of the college or the university, kasi nga, iba't iba yung base ng mga organizations. Thank you, Justice. Mr. Chair.
Director Libeta, sa CHED ka pala, no? CHED, not DepEd. So, wala tayong rep from DepEd, no? Kasi, meron ba? We invited DepEd, but they're not present. So, are you done?
Support on that suggestion. Maybe in section 7, instead of faculty advisor, maybe we can put that section as school authority. And the school authority, though mentioned in section 6, they have all those authority to establish recognition and registration of those fraternities.
So, thank you. Thank you for that. And we now recognize ASEC Ronald Cardema of the National Youth Commission. Ronald?
Good morning, Mr. Chair. On the part of the National Youth Commission, we strongly support this measure that makes all acts of hazing illegal instead of just regulating the level of hazing that can be initiated to individuals. As we have seen in the recent hazing incident, binola-bola lang yung bata about brotherhood. Yung bata, binigay ang kanyang sarili ng buong buo. At nung biglang namatay, parang tinapon na lamang na karne yung bata. That is not brotherhood. And that is not the kind of foundation we want in the youth organizations of our country. Hazing is not necessary to build strong organizations. The National Youth Commission believes that brotherhood or one's dedication to an organization should be measured not by the many paddle hits one can take, but by his commitment to the mission and vision of the organization. So our recommendations are, one, the definition of the term organizations should explicitly cover not just school-based organizations, but also community-based organizations. It is important to ensure that any possible occurrence of hazing should be prevented, whether inside or outside the school. Number two, a set of regulations should be added for hazing perpetrators that are below 18 years old, because there are also fraternities in high schools. Number three, a tighter mechanism for reporting and monitoring should be in place. Aside from the registration and reporting of fraternities and youth organizations in schools, may we also require them, especially non-school-based organizations and community-based fraternities, to register under the local youth development office of their respective LGUs. Number four, an agency should be tasked to conduct hazing education among schools and communities regularly, and to motivate fraternities and youth organizations that instead of hazing their members and neophytes, they should create more ceremonies and indoctrinations that enhance their sense of nationalism and adherence to the core values of their organization. And if they really want to test the physical stamina of their incoming members, let's motivate these fraternities and youth organizations to have their members participate in government-controlled short trainings like disaster response training, martial arts training, sports training, basic military reservist training, and other physical trainings that truly contribute to well-being and nation building. Thank you very much, Mr. Chair.
Thank you, Ronald. No? Were you part of the TWG that hindi kaya no. Anyway, many of the things that you mentioned are already incorporated. If not, some are already talking about programs that can very well be crafted by school authorities, etc., and that could also be part of the IRR and the interagency committee. So I think well covered naman yan, yung you know, defining what kind of training they should go to is something that can be done within the school. Tapos I have some problems with creating another agency to monitor or to handle all of these things because dapat kasi i-institutionalize natin ito eh. I mean, you know, dapat yung in the, you know, creating another organization to look over the shoulders of everyone is something that may be counterproductive at the end of the day, because probably what is more important is that yung institution itself and the systems within that institutions will carry the program through. So I don't think we need another layer. Ang dami na nating ahensya para i-handle or i-manage or i-coordinate itong mga activities na to, and it could very well be the school itself. Kanya nga we're giving more authority to the school than anything, and this is why registration is part of this. Oversight and monitoring is also a responsibility of the school, and likewise the community. So with that, do we still have many other si Chief Superintendent Delphine from PNPA?
Yes, sir. Maraming salamat po. Ako po si Police Chief Superintendent Randolph Delphine, ang Director po ng Philippine National Police Academy. On the part of the Philippine National Police Academy, we support the amendment of the Anti-Hazing Law. Sa ngayon po, we have 963 cadets, and since the start of the acceptance of the new cadets last May 1, until now, we do not have any incident of hazing at the Philippine National Police Academy. Bakit po? Because we properly implement the anti-hazing law. It's a matter of how we're going to implement. Alam po naman namin din sa Philippine National Police Academy na kung hindi namin i-implement, we are responsible. Me as the director of the Philippine National Police Academy, I am responsible for not implementing the anti-hazing law. Narinig ko po kanina yung sinabi ni Sir Director, yung about collaborative meetings. Ang ginagawa po namin doon ay yung covenant. We have the covenant from all aboard the cadets, from first year up to fourth year graduating cadets, that we do not have, we adhere to no to hazing policy. And so, we constantly remind them about the effects of hazing. Kasi there is a big borderline between discipline and hazing. If you're going to destroy the ambitions and aspirations of life of one individual, mali na po yun. That is already maltreatment or hazing, and at the same time, yung pong ambisyon ng isang tao mawawala. And the effects of the hazing, if ever to an upper class cadet, is properly emphasized. A criminal offense will be filed against him, and at the same time, an administrative case will be filed against him. Dismiss po siya kagad. So, alam ng mga kadete namin na kapag if they will violate hazing, the anti-hazing law, wala na po sila. So, sa nakikita ko po, sir, it's only a matter of how we are going to implement the anti-hazing law. Kahit ano pong amendment, rest assured, we will implement it properly. Maraming salamat po.
Yun, tama yun. Actually, ang problema natin Pilipino, yung kung paano mag-implement ng batas. Magaganda yung batas natin, di lang natin ma-implement ng maayos. Because either merong prejudices, biases yung mga nag-i-implement. No? So, tama yun. And that's a good idea, yung sinabi mo, that probably you can share in the interagency committee against hazing that will be formed for purposes of crafting the implementing rules and regulations. Hindi ko nakita yung PNPA dito as an institution na maging miyembro nito. Perhaps, if I may suggest, to also include PNPA kasi NPMA, no? Dito sa kasi maraming experiences itong dalawang institutions na to when it comes to hazing. Yeah. So we will learn a lot from you. And so your participation and contribution is most welcome. Thank you. We now recognize Major Gerald Cabrera from PMA.
Good morning, Your Honors. As far as PMA is concerned, Your Honors, we actually subscribe and share the same comment with the PNPA. In PMA, we strictly observe and implement the no hazing policy. In fact, Your Honor, the penalty for those caught committing hazing is dismissal from the academy. As for the measures and the provisions of the proposed bill, Your Honors, we do not in any way interpose any objections because the provisions, Your Honor, does not run counter to the methods of teaching and training of our cadets. So that's all, Your Honor.
So okay kayong lahat, So meron pa ba? Major Eduardo Esquivias from AFP.
Good morning, Mr. Chair, the honorable members of the committee. We also fully support this bill. However, Your Honor, we noticed that in the law, RA 8049, pinagsama po ang hazing and initiation rights. Whereas in the proposed bill, nakahiwalay po yung definition ng hazing and yung initiation rights. And we also note po yung nire-state po yung definition ng organization which includes the AFP and the PNP, and yung mga practices po shall not be considered as hazing. However, since in the proposed bill po, dalawa po, hiniwalay na po ang hazing and initiation rights, we want to seek clarification po and kung pwede po i-recommend under line number 5 po ng second page, page 2, na ang nakalagay po doon, starting with line 4, no, shall not be considered as hazing. Kung pwede po idagdag na shall not be considered as hazing or initiation rights. Since pinaghiwalay po yung yung dalawa. So if I may restate po, under the law, ang hazing and initiation is covered under Section 1. So, isa lang po ang definition niya. Hazing is an initiation right or practice. No? Under the proposed bill po, ipinaghiwalay na po sila. Ang magiging effect po ba nun, since pinaghiwalay sila, we will be covered by the regulations on the conduct of initiation rights. So para mawala po yung doubt on that, kung pwede po na isama po yung underline number 5, it shall not be considered as hazing or initiation rights.
Thank you for that, sir. That's duly noted.
Thank you
We'll
very
take
much,
that into consideration. Salamat po.
Yes, and thank you po.
Have we heard everyone? So looks like we have a consensus among all of the resource persons that this is the law that we need to immediately address the many concerns, particularly of the most recent incident that happened on a hazing victim, and as I said, medyo very timely tayo. In fact, we're way ahead of all others in terms of the work that Congress, which is a legislative body, is doing. No, we are no longer doing this in aid of legislation. We are already in legislating what needs to be done, because from the many comments that we have heard today, which are all also coming from those exposed to activities of fraternities, sororities, and even organizations that are known for engaging in hazing activities and initiation rights. So we did quite well in terms of getting all of our resources together, resource persons together, to craft a comprehensive law, and so we welcome all of your inputs today. So what is the pleasure of Congressman Garbin?
Mr. Chair, I move for the approval of the substitute bill to House Bill number 3467, subject to some amendments in style, Mr. Chair.
There being a motion to approve, duly seconded, without any objection, this substitute bill on the anti-hazing law is approved.
Mr. Chair, ako po ay nagpapasalamat sa inyo. Nagpapasalamat ako napunta sa Committee on Justice. Doon na-refer yung batas na to. And we really thought this out. We considered all the opinions from the first meeting, even beforehand, and included also the version of the 16th Congress, the versions of the other members of Congress, so that it would be a bill that's really crafted nicely and would still consider the inputs of the guests here present. Maraming salamat, Mr. Chair.
Maraming salamat din, BH, for a job well done. I think the technical working group and all resource persons who work on this deserve a big round of applause.
Mr. Chair, nagpapasalamat din po ako sa mga resource persons, especially during the first hearing and then the TWG and today. Maraming salamat po.
Okay, so those resource persons of the first agenda item is now excused. So we will now go to part 2, and particularly the PNP. We would like to ask you to stay because this is a very important piece of legislation that we will tackle in the second part. And we will have... boss, dito muna kayo. Huwag muna kayo umalis. Okay. Napaka-importante nito. Pero, diyan ang masan nila sa PNP.
PNP siya. Siya ang PNPA.
Boss, kailangan ko rin ng PNPA dito.
PNPA?
PNPA, Police Academy, kasi this has something to do with investigation. Baka, please stay.
Thank you, sir.
Please stay. Kung pwede, if you can stay, kasi yung training of
Si General Manzanilla, sir.
So, hearing is suspended for 5 minutes. Okay, hearing is resumed. Part 2. We now conduct the hearing of the Subcommittee on Investigation and Enforcement Reforms. We now consider substitute bill to House Bills number 8 and House Bills number 8, 775, and 3296 by Representatives Pariñas, Alvarez, Speaker Alvarez, Andaya, Duavit, Coangco, Co, Abu, Salimbangon, Nograles, Suarez, Batocabe, Aglipay, Villar, and Escudero Re on the matter of Criminal Investigation System Act. Nasaan ba yung ano? So, may I now recognize the COMSEC, who is the chair of the TWG, on the output of the TWG on the substitute bill of the Criminal Investigation System Act. Before I recognize you, let me just explain to you the purpose of or the rationale for this pursuing this Criminal Investigation Act. In the previous hearings, I mentioned that there is need for some structural reforms in the way we conduct investigation. And in particular, we are looking at simplifying the processes because as it is now, the process is quite tedious and complex, and to a certain extent medyo nakakalito na eh. Meron tayong, you have a situation where the Department of Justice conducts preliminary investigation. Tapos and because they are performing a quasi-judicial function, they are expected the cold neutrality of a judge. Kanya kahit sila prosecutor na dapat patibayin nila yung kaso, ine-expect na hindi sila ganon at magiging neutral sila because adversarial yung process at the PI level where you have a complainant and a respondent. And then, ang problema nga ay on most occasions, ang complainant ay yung police. Di ba? PNP versus kung sino man, ano? But there are a host of other concerns involving how police conducts themselves in the enforcement and also on the investigation. That's why I'd like to always refer to the case of Mayor Espinosa as an indictment of the criminal justice system, and it all starts with the police. Yun ang pinakamabigat. Nagsisimula sa kapulisan. Bakit? Yung enforcement, hindi mangyari na mahuli yung victim, yung culprit, yung kriminal. Kanya yung kriminal nakakapaghasik pa ng lagim, nananakot ng witness, kanya hindi matuloy-tuloy yung kaso. And hanggat hindi na-aresto yung kriminal, ay hindi magsisimula ang kaso dahil walang jurisdiction ng korte. Kanya napaka-importante po ng police. That's why in addition to General Manzanilla, I also requested PNPA si General Delfin to stay because napaka-importante po to sa training pa lang ng police. Dapat malinaw itong, although I'm sure tinuturo nyo ito, pero kung hindi gagawin ng trabaho because for whatever reason hindi ginawa yung trabaho, yan ang pinakamabigat. Ngayon, kung hindi natin matuturuan kung paano mag-imbestiga yung mga pulis or kung paano sumuporta yung pulis sa mga prosecutors para mas matibay yung kaso, maganda yung case building or case build-up, ay napakahirap po ng situation natin. And we will end up having a bungled case that cannot even proceed PI or much more yung court trial, ano. So yun po yung isang problema. Can you imagine a judge issuing a search warrant inside the prison cell? Nakakatawa, siguro tayo lang ang merong ganon. Nasa kulungan ay nag-issue ng warrant. But, I think that is the most stupid thing to do. Pero, paano ang gagawin mo kung ikaw ang judge na meron ng baril at saka may shabu sa loob? Ibig sabihin, yung correctional, one of the pillars of the criminal justice system, ay hindi ginawa rin na ng trabaho. Kanya may baril sa loob. So, nagulo yung sistema ng hudikatura, magulo yung sistema ng koreksyonal, tapos eto na po yung pulis. Dahil may search warrant, nag-conduct ng search in the wee hours of the morning. Paano nangyari ito? Hindi ko maintindihan kung bakit nangyayari po ito. Ang masama pa, dinisarmahan yung mga BJMP guards. Mga kasamahan din nila yon, dinisarmahan yung mga CCTV yata o basta ko anong magbibigay ng traceability of what had happened there, tinanggal or sinira or whatever para walang testigo. So, pulis po ito. Tapos, dumating po yung kaso sa Department of Justice, prosecution naman. Ayun, ang ginawa ni Secretary Vit Aguirre, ibinaba from murder to homicide. Parang nagwala yung mga kasamahan namin sa Senate. At kinakastigo si Vit Aguirre, Secretary Aguirre. Ako na, interview ko. Pero sabi ko, ano magagawa mo? Kung ikaw yung Secretary of Justice, tiningnan mo, wala ebidensya eh. Bakit walang ebidensya? Kasi yung mga pulis, sila mismo, ay nagtaguan sila, nagtakipan ng cover your back, ika nga. Wala kang mapiga ngayon, kanya nagmukhang loko yung Senado. Sorry for that, that is not meant to... that is not to insinuate. Pero nakakatawa yung hearing na yun na kung saan yung mga pulis ay alam mo, nagtatakipan. Na tapos pag maiipit na sasabihin, I invoke my right to self-incrimination, to silence, and so on and so forth. So, anong mapipiga ng Senado? Pati legislature na apektuhan dahil sa dysfunctional criminal justice system. And what do you expect the court to do? Meron kaya tayong mako-convict dito dahil walang ebidensya, tinakpan yung ebidensya, kinover up ng police, and so on and so forth, etc., etc. And ito na po, nagkagulo na po yung criminal justice system. And this is now what this committee wants to reform. And this is what this committee is now looking into on the matter of investigation and enforcement reforms that are needed para po yung fifth pillar, which is the community, manumbalik po ang tiwala nila sa ating criminal justice system. Have you ever wondered why wala pong sumusunod dito sa Pilipinas? Pero pag nasa Amerika ang mga Pilipino, napakadisiplinado. Binibigyan ng maraming recognition dahil law-abiding citizen. Pero pagbalik po dito sa Pilipinas, ay nag-iiba ang pagkatao ng Pilipino. Parang gustong i-violate lahat ng mababiolate. Why? Because they know they can get away with the law. They can buy their way to freedom. That is the sorry state of our criminal justice system, and this is the reason why this committee under the 17th Congress is hell-bent on pursuing reforms, taking initiatives at reforming the criminal justice system. And criminal investigation and enforcement is one of the weakest links in this system. Kaya hinihingi po namin ang participation nyo. For now, we will request that the chair of the TWG, Attorney De Lorino, to brief us on what transpired. But at the same time, we will ask Justice Villanueva to share with us yung models, a good model that probably can be adopted in the Philippines that will do away with preliminary investigation, that will strengthen case building, that will shorten the process for enforcement to be able to do their jobs and do their jobs well, no? So yun yung gagawin natin. So now we recognize Attorney De Lorino. Noli,
Thank you, Your Honor. Good morning.
I'm chairing a meeting.
On August 8, 2017, the subcommittee meeting chaired by Representative Strike Revilla created the technical working group, and he designated the Committee Secretary of the Committee on Justice as to chair the technical working group, which included members from the Department of Justice, the Office of the Ombudsman, the Office of the Court Administrator, the National Prosecution Service, the Public Attorney's Office, the Philippine Judges Association, the NBI, and the PNP. On September 7, 2017, the technical working group convened to discuss the provisions of House Bill numbers 8 and 775. The following members of the TWG were present: the Committee Secretary as the designated chair, State Prosecutor Hazel Desena Valdez of the DOJ, Attorney Nazario Bancoro of the Public Attorney's Office, Judge Raquelin Vasquez and Judge Mariante Zuraik of the Philippine Judges Association, Police Director Roel Obusan of the PNP, and together with Police Director Obusan were Police Chief Superintendent Fausto Manzanilla Jr., Police Senior Superintendent Orlando Melchor, and Police Chief Inspector Al Paglinawan. During that meeting, the TWG proposed two major changes to the House bills. First is the elevation of the standard of evidence from probable cause to clear and convincing evidence. The TWG agreed to adopt the standard of clear and convincing evidence for the investigating prosecutor to determine whether a criminal complaint may be filed in court. This is a higher standard than probable cause currently used under existing laws and prima facie as proposed in the two bills. Prosecutor Valdez proposed this standard as this would lead to fewer criminal cases filed and a higher probability of conviction, since the evidence gathered during investigation need to be clear and convincing before a case is filed. The representatives from the PAO and the Philippine Judges Association also agreed with the proposal. Another major change that the TWG made is the deletion of the proposed preliminary hearing stage, because in the original bills, the criminal investigation was supposed to have been composed of two stages, the criminal investigation stage and then the preliminary hearing stage. It was agreed that the preliminary hearing stage, which imposes duties on the judge to conduct a preliminary determination if the case would proceed, should be deleted because it may be construed as encroaching upon the rulemaking power of the Supreme Court in all matters relating to court procedure, and it may also violate the constitutional principle of separation of powers. This is consistent with the most recent ruling of the Supreme Court in the case of Estepona versus Frank Lobrigo, reiterating the rulings in Echagaray versus Secretary of Justice and Carpio Morales versus CA, where the Supreme Court held that the power to promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts belongs exclusively to the Supreme Court. Just a brief background, in the Estepona decision, the Supreme Court struck down as unconstitutional the provisions in RA 9165 prohibiting plea bargaining in drug cases. According to the Supreme Court, plea bargaining is a rule of procedure, and since the rules of court expressly allow plea bargaining in criminal cases, the prohibition in RA 9165 unduly encroaches upon the rulemaking power of the SC. So, before the TWG agreed on the deletion of this provision, it was clarified if there are rights of an accused, it was asked whether or not the rights of an accused will be violated if the present practice of requiring respondents or accused to submit counter affidavits is abolished under the proposed measure. The members of the TWG agreed that a person under criminal investigation does not have duly protected constitutional rights yet, except those under the custodial investigation. And it is only upon the filing of a criminal information or complaint that the right to due process will attach. Furthermore, the TWG members also noted that under the present system, once a respondent or accused has been informed that a preliminary investigation is being conducted, since the respondent is required to submit a counter affidavit, most respondents or accused would abscond and can no longer be found. Thus, the proposed inquisitorial criminal investigation system will be more effective in bringing perpetrators to justice. So we have distributed copies of the substitute bill, which is now which is the product of the technical working group conducted by the TWG. Thank you, Your Honor.
So let's reserve our comments for later. For now, we would like to now recognize Justice Villanueva for a briefing on a model criminal investigation system that is being implemented in, I think, Korea?
Yeah, South Korea.
South Korea. And,
Yes, Your Honor.
And to a certain extent, U.S. But before that, may I just recognize or acknowledge the presence of Congresswoman Escudero. Please proceed.
Thank you, Mr. Chairman. Thank you, Your Honors. I'm grateful for this opportunity to make this presentation. I do this not in my official capacity as Deputy Court Administrator, but more importantly in obedience to the request of the committee to make this presentation. I would like to state for the record, Your Honors, that the basis or the source of this presentation is the result of what we learned from a partnership program that was sponsored by the Korea International Cooperation Agency, KOICA, and at the same time from materials gathered from one of the prosecutors, who is also a professor at the Judicial Research and Training Institute of the Supreme Court of South Korea. And with that, Your Honors, I don't want to take much of the time of the committee. I will make a very brief presentation, Your Honors, and I hope that one way or the other this will give you an idea on how the South Koreans, or the conduct the criminal investigation. I guess before making my presentation, I would already make mention, Your Honors, there was one thing that one way or the other that caught your attention regarding this matter about the implementation of a search warrant involving Mayor Espinosa. If the rules that are being observed in South Korea would have been adopted here in our jurisdiction, and which is part of the recommendations, or at least part of the proposed bill, Your Honor, that would have been prevented because with respect to the conduct of any search, this cannot be obtained in the under the system of South Korea without the involvement of prosecutors. Unlike in so far as that incident is concerned, that was a purely police operation, for which reason nobody could just be involved in other than the police officers. So with that, Your Honors, next slide please. Allow me to just make this very brief presentation on the Korean Prosecution Service. Next please. The Korean Prosecution Service actually started in August of 1948. Why? Because it was after the war that actually Korea was able to be one way or the other liberated from the control of Japan. That was in 1948. And in 1962, the Korean Constitution actually enshrined, included a particular provision which makes special mention of prosecutors, And what is that? With respect to securing arrest warrants or search and seizure warrants, this is in the within the exclusive province, of prosecutors. So there is a clear mention of prosecutors in the Korean Constitution, unlike in our case. There is not that kind of mention about the authorities being given to our prosecutors. And that particularly Article 12 of the Constitution of Korea mentions that warrants issued by a judge through due process upon, take note, the request of a prosecutor. It's only the prosecutor who will make that request, not police officers, who can do that. Then that's well within the authorities being given to them. And if there is a need to detain an accused who is charged for a crime where the penalty is more than 3 years, the prosecutors again can actually ask for warrants of arrest. So that is provided in their constitution. I'm mentioning this because there is nothing in our constitution similar to this kind of provision. Next, please. The organization of the Korean Prosecution Service is actually twofold. One is, one it is headed similar to our case, headed by a Prosecutor General, and then of course there are offices of the Prosecution Service. One is the Supreme Prosecution Office, headed by the Prosecutor General, and then the High Prosecutor's Office, which involves cases within the cognizable by their higher courts, and so on and so forth, which is similar to our more or less structure. This is next, please. I'm just showing the organizational chart of the Korean Prosecution Service. I'm really sorry if it's not very clear, but it just shows there that above there insofar as the prosecution service is concerned, it is recognized that there is only one supreme prosecutor, Prosecutor General. What is now the relationship? Next, please. What is now the relationship of judicial police officers and the prosecutors? By definition, judicial police officers are members of the law enforcement agencies and all other personnel involved in investigations. For example, in the Bureau of Customs, if there is a unit there involved in investigation, then that is considered as a judicial police officer. What is the import of this particular term? Insofar as the Korean Prosecution Service is concerned, any investigation can be done by a judicial officer. However, the results of this investigation will be passed to the prosecutor office. In other words, there is no indictment can be done without the say of the involvement, if I may, of the prosecutor in Korea. In other words, the police cannot just directly file a case without the involvement of the prosecutor. What else? The prosecutors can actually decide on their own to continue with the investigation after the judicial police officers are done with the investigation, or